Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Abitron Austria GmbH v. Hetronic International Incorporated. In this case, the court considered this issue. Does the Lanham Act permit the owner of a U.S. registered trademark to recover damages for the use of that trademark when the infringement occurred outside the United States and is not likely to cause confusion in the United States? The case was decided on June 29, 2023. The Supreme Court held that the Lanham Act extends trademark protection only to claims where the infringing use in commerce is domestic. Justice Samuel Alito authored the majority opinion of the court. Unless Congress explicitly states otherwise, U.S. laws are generally presumed to apply only within the territorial jurisdiction of the United States. This presumption helps avoid conflicts with other countries, and is premised on the idea that Congress typically legislates with domestic matters in mind. To apply the presumption against extraterritoriality, courts apply a two-step framework. First, a court must ask whether Congress has explicitly indicated that the statute should apply to foreign conduct. If not, then the second step is to ask whether the lawsuit seeks a permissible domestic or impermissible foreign application of the law. Applying that two-step framework here, the court concluded that the Lanham Act applies only to claims where the infringing use is domestic. First, neither Section 1114(1)(a) nor Section 1125(a)(1) explicitly indicates that the statute should apply to foreign conduct. They prohibit the use in commerce of protected marks that are likely to cause confusion. A mere reference to foreign commerce does not make a statute extraterritorial. Second, the focus of the statute is on the use in commerce that is likely to cause confusion, which is domestic conduct. Justice Cotton G. Brown Jackson filed a concurring opinion to elaborate on what it means to use a trademark in commerce. Justice Sonia Sotomayor filed an opinion concurring in the judgment, in which Chief Justice John Roberts and Justices Elena Kagan and Amy Coney Barrett joined, arguing that while the majority reached the correct conclusion, in her view the Lanham Act extends to activities carried out abroad when there is a likelihood of consumer confusion in the United States. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Alito delivered the opinion of the court. This case requires us to decide the foreign reach of 15 U.S.C. Section 1114(1)(a) and Section 1125(a). 1-2 provisions of the Lanham Act that prohibit trademark infringement. Applying the presumption against extraterritoriality, we hold that these provisions are not extraterritorial, and that they extend only to claims where the claimed infringing use in commerce is domestic. This case concerns a trademark dispute between a United States company, Hetronic International Incorporated, and 6 foreign parties, 5 companies and 1 individual, collectively Abitron. Hetronic manufactures radio remote controls for construction equipment. It sells and services these products, which employ a distinctive black and yellow color scheme to distinguish them from those of its competitors, in more than 45 countries. Abitron originally operated as a licensed distributor for Hetronic, but it later concluded that it held the rights to much of Hetronic's intellectual property, including the marks on the products at issue in this suit. After reverse engineering Hetronic's products, Abitron began to sell Hetronic-branded products that incorporated parts sourced from third parties. Abitron mostly sold its products in Europe, but it also made some direct sales into the United States. Hetronic sued Abitron in the Western District of Oklahoma for, as relevant here, trademark violations under 2 related provisions of the Lanham Act. First, it invokes Section 1114(1)(a), which prohibits the unauthorized use in commerce of any reproduction of a registered mark in connection with the sale, offering for sale, distribution, or advertising of any goods or services when such use is likely to cause confusion. Hetronic also invoked Section 1125(a)(1), which prohibits the use in commerce of a protected mark, whether registered or not, that is likely to cause confusion. Hetronic sought damages under these provisions for Abitron's infringing acts worldwide. Throughout the proceedings below, Abitron argued that Hetronic sought an impermissible extraterritorial application of the Lanham Act, but the district court rejected this argument, and a jury later awarded Hetronic approximately $96 million in damages related to Abitron's global employment of Hetronic's marks. This amount thus included damages from Abitron's direct sales to consumers in the United States, its foreign sales of products for which the foreign buyers designated the United States as the ultimate destination, and its foreign sales of products that did not end up in the United States. The district court later entered a permanent injunction preventing Abitron from using the marks anywhere in the world. On appeal, the 10th Circuit narrowed the injunction to cover only certain countries, but otherwise affirmed the judgment. It concluded that the Lanham Act extended to all of Abitron's foreign infringing conduct because the impacts within the United States were of a sufficient character and magnitude, as would give the United States a reasonably strong interest in the litigation. We granted certiorari to resolve a circuit split over the extraterritorial reach of the Lanham Act. It is a long-standing principle of American law that legislation of Congress, unless a contrary intent appears, is meant to apply only within the territorial jurisdiction of the United States. We have repeatedly explained that this principle, which we call the presumption against extraterritoriality, refers to a presumption against application to conduct in the territory of another sovereign. In other words, exclusively foreign conduct is generally the domain of foreign law. The presumption serves to avoid the international discord that can result when U.S. law is applied to conduct in foreign countries, and reflects the common-sense notion that Congress generally legislates with domestic concerns in mind. Applying the presumption against extraterritoriality involves a two-step framework. At step 1, we determine whether a provision is extraterritorial, and that determination turns on whether Congress has affirmatively and unmistakably instructed that the provision at issue should apply to foreign conduct. If Congress has provided an unmistakable instruction that the provision is extraterritorial, then claims alleging exclusively foreign conduct may proceed, subject to the limits Congress has, or has not, imposed on the statute's foreign application. If a provision is not extraterritorial, we move to step 2, which resolves whether the suit seeks a permissible domestic or impermissible foreign application of the provision. To make that determination, courts must start by identifying the focus of congressional concern underlying the provision at issue. The focus of a statute is the object of its solicitude, which can include the conduct it seeks to regulate, as well as the parties and interests it seeks to protect or vindicate. Step 2 does not end with identifying statutory focus. We have repeatedly and explicitly held that courts must identify the statute's focus, and ask whether the conduct relevant to that focus occurred in United States territory. Thus, to prove that a claim involves a domestic application of a statute, plaintiffs must establish that the conduct relevant to the statute's focus occurred in the United States. Step 2 is designed to apply the presumption against extraterritoriality to claims that involve both domestic and foreign activity, separating the activity that matters from the activity that does not. After all, we have long recognized that the presumption would be meaningless if any domestic conduct could defeat it. Thus, if the conduct relevant to the statute's focus occurred in the United States, then the case involves a permissible domestic application of the statute, even if other conduct occurred abroad. And if the relevant conduct occurred in another country, then the case involves an impermissible extraterritorial application, regardless of any other conduct that occurred in U.S. territory. Of course, if all the conduct regarding the violations took place outside the United States, then courts do not need to determine the statute's focus at all. In that circumstance, there would be no domestic conduct that could be relevant to any focus, so the focus test has no filtering role to play. With this well-established framework in mind, the first question is whether the relevant provisions of the Lanham Act provide a clear, affirmative indication that they apply extraterritorially. They do not? It is a rare statute that clearly evidences extraterritorial effect despite lacking an express statement of extraterritoriality. Our decision in RJR Nabisco illustrates the clarity required at step 1 of our framework. There, we held that the Racketeer Influenced and Corrupt Organizations Act could have extraterritorial application in some circumstances, because many of its predicate offenses plainly apply to at least some foreign conduct, and at least one predicate applies only to conduct occurring outside the United States. Here, neither provision at issue provides an express statement of extraterritorial application, or any other clear indication that it is one of the rare provisions that nonetheless applies abroad. Both simply prohibit the use in commerce, under congressionally prescribed conditions, of protected trademarks when that use is likely to cause confusion. Hetronic acknowledges that neither provision on its own signals extraterritorial application, but it argues that the requisite indication can be found in the Lanham Act's definition of commerce, which applies to both provisions. Under that definition, commerce means all commerce which may lawfully be regulated by Congress. Hetronic offers 2 reasons why this definition is sufficient to rebut the presumption against extraterritoriality. First, it argues that the language naturally leads to this result because Congress can lawfully regulate foreign conduct under the Foreign Commerce Clause. Second, it contends that extraterritoriality is confirmed by the fact that this definition is unique in the U.S. Code, and thus differs from what it describes as boilerplate definitions of commerce in other statutes. Neither reason is sufficient. When applying the presumption, we have repeatedly held that even statutes that expressly refer to foreign commerce when defining commerce are not extraterritorial. This conclusion dooms Hetronic's argument. If an express statutory reference to foreign commerce is not enough to rebut the presumption, the same must be true of a definition of commerce that refers to Congress's authority to regulate foreign commerce. That result does not change simply because the provision refers to all commerce Congress can regulate. And the mere fact that the Lanham Act contains a substantively similar definition that departs from the so-called boilerplate definitions used in other statutes cannot justify a different conclusion either. Because Section 1114(1)A and Section 1125(a)(1) are not extraterritorial, we must consider when claims involve domestic applications of these provisions. As discussed above, the proper test requires determining the provision's focus and then ascertaining whether Hetronic can establish that the conduct relevant to that focus occurred in the United States. Much of the parties' dispute in this case misses this critical point, and centers on the focus of the relevant provisions without regard to the conduct relevant to that focus. Abitron contends that Section 1114(1)(a) and Section 1125(a) 1 focus on preventing infringing use of trademarks, while Hetronic argues that they focus both on protecting the goodwill of mark owners and on preventing consumer confusion. The United States, as amicus curiae, argues that the provisions focus on only likely consumer confusion. The parties all seek support for their positions in Steele v. Bulova Watch Company, but that decision is of little assistance here. There, we considered a suit alleging that the defendant, through activity in both the United States and Mexico, had violated the Lanham Act by producing and selling watches stamped with a trademark that was protected in the United States. Although we allowed the claim to proceed, our analysis understandably did not follow the two-step framework that we would develop decades later. Our decision was instead narrow and fact-bound. It rested on the judgment that the facts in the record, when viewed as a whole, were sufficient to rebut the presumption against extraterritoriality. In reaching this conclusion, we repeatedly emphasized both that the defendant committed essential steps in the course of his infringing conduct in the United States, and that his conduct was likely to and did cause consumer confusion in the United States. Because Steele implicated both domestic conduct and a likelihood of domestic confusion, it does not tell us which one determines the domestic applications of Section 1114(1)(a) and Section 1125(a)(1). With Steele put aside then, we think the parties' particular debate over the focus of Section 1114(1)(a) and Section 1125(a)(1) in the abstract does not exhaust the relevant inquiry. The ultimate question regarding permissible domestic application turns on the location of the conduct relevant to the focus. And the conduct relevant to any focus the parties have proffered is infringing use in commerce, as the Act defines it. This conclusion follows from the text and context of Section 1114(1)(a) and Section 1125(a)(1. Both provisions prohibit the unauthorized use in commerce of a protected trademark when, among other things, that use is likely to cause confusion. In other words, Congress proscribed the use of a mark in commerce under certain conditions. This conduct, to be sure, must create a sufficient risk of confusion, but confusion is not a separate requirement. Rather, it is simply a necessary characteristic of an offending use. Because Congress has premised liability on a specific action, a particular sort of use in commerce, that specific action would be the conduct relevant to any focus on offer today. In sum, as this case comes to us, use in commerce is the conduct relevant to any potential focus of Section 1114(1)(a) and Section 1125(a)(1), because Congress deemed a violation of either provision to occur each time a mark is used in commerce in the way Congress described, with no need for any actual confusion. Under Step 2 of our extraterritoriality standard, then, use in commerce provides the dividing line between foreign and domestic applications of these Lanham Act provisions. Resisting this straightforward application of our precedent, Justice Sotomayor concludes that Step 2 of our extraterritoriality framework turns solely on whether the object of the statute's focus is found in, or occurs in, the United States. Applied to the Lanham Act, the upshot of this focus-only standard is that any claim involving a likelihood of consumer confusion in the United States would be a domestic application of the Act. This approach is wrong, and it would give the Lanham Act an untenably broad reach that undermines our extraterritoriality framework. To justify looking only to a provision's focus, Justice Sotomayor maintains that an application of a statute can still be domestic when foreign conduct is implicated. If this assertion simply means that a permissible domestic application can occur even when some foreign activity is involved in the case, then it is true but misses the point. When a claim involves both domestic and foreign activity, the question is whether the conduct relevant to the statute's focus occurred in the United States. If that conduct occurred in the United States, then the case involves a permissible domestic application of the statute, even if other conduct occurred abroad. But if the conduct relevant to the focus occurred in a foreign country, then the case involves an impermissible extraterritorial application regardless of any other conduct that occurred in U.S. territory. These holdings were not, as Justice Sotomayor suggests, premised on this court's first concluding, or assuming without deciding, that the focus of the provision at issue was conduct. They were unambiguously part of this court's articulation of the two-step framework, and, in each case, these holdings came before we began analyzing the focus of the provisions at issue. For this reason, none of our cases has ever held that statutory focus was dispositive at Step 2 of our framework. To the contrary, we have acknowledged that courts do not need to determine a statute's focus when all conduct regarding the violations took place outside the United States. That conclusion, as well as the decisions applying it, are inexplicable under a focus-only standard. Beyond straying from established precedent, a focus-only approach would create headaches for lower courts required to grapple with this new approach. For statutes regulating conduct, the location of the conduct relevant to the focus provides a clear signal at both steps of our two-step framework. Under Justice Sotomayor's standard, by contrast, litigants and lower courts are told that the Step 2 inquiry turns on the focus alone, which can be conduct, parties, or interests that Congress sought to protect or regulate. As a result, almost any claim involving exclusively foreign conduct could be repackaged as a domestic application, and almost any claim under a non-extraterritorial provision could be defeated by labeling it a foreign application, even if the conduct at issue was exclusively domestic. This is far from the measure of certainty that the presumption against extraterritoriality is designed to provide. Justice Sotomayor's expansive understanding of the Lanham Act's domestic applications threatens to negate the presumption against extraterritoriality. In Morrison, we warned that the presumption against extraterritorial application would be a craven watchdog indeed if it retreated to its kennel whenever some domestic activity is involved in the case. If a claim under the Act involves a domestic application whenever particular effects are likely to occur in the United States, the watchdog is nothing more than a muzzled chihuahua. Under such a test, it would not even be necessary that some domestic activity be involved. It would be enough for there to be merely a likelihood of an effect in this country. Applying that standard here would require even less connection to the United States than some explicitly extraterritorial statutes, which must have, at a minimum, actual domestic effects to be invoked. This approach threatens international discord. In nearly all countries, including the United States, trademark law is territorial, i.e., a trademark is recognized as having a separate existence in each sovereign territory in which it is registered or legally recognized as a mark. Thus, each country is empowered to grant trademark rights and police infringement within its borders. This principle has long been enshrined in international law. Under the Paris Convention for the Protection of Industrial Property, a mark duly registered in a country of the Union shall be regarded as independent of marks registered in other countries of the Union, and the seizure of infringing goods is authorized on importation to a country where such mark or trade name is entitled to legal protection. The Convention likewise provides mechanisms for trademark holders to secure trademark protection in other countries under the domestic law of those countries. The Lanham Act, which is designed to implement treaties and conventions respecting trademarks, incorporates this territorial premise, mandating that registration of a foreign trademark in the United States shall be independent of the registration in the country of origin, and that the rights of that mark in the United States are governed by domestic law. Because of the territorial nature of trademarks, probability of incompatibility with the applicable laws of other counties is so obvious that if Congress intended such foreign application, it would have addressed the subject of conflicts with foreign laws and procedures. The use of a mark, even confined to one country, will often have effects that radiate to any number of countries. And when determining exactly what form of abstract consumer confusion is sufficient in a given case, the judiciary would be thrust into the unappetizing task of navigating foreign policy disputes belonging to the political branches. If enough countries took this approach, the trademark system would collapse. This tension has not been lost on other sovereign nations. The European Commission gravely warns this court against applying the Lanham Act to acts of infringement occurring in the European Union and outside of the United States. To police allegations of infringement occurring in Germany, it continues, would be an unseemly act of meddling in extraterritorial affairs, given international treaty obligations that equally bind the United States. As the Commission and other foreign amici recognize, the system only works if all participating states respect their obligations, including the limits on their power. It thus bears repeating our long-standing admonition that United States law governs domestically but does not rule the world. In sum, we hold that Section 1114(1)(a) and Section 1125(a)(1) are not extraterritorial, and that the infringing use in commerce of a trademark provides the dividing line between foreign and domestic applications of these provisions. Under the Act, the term use in commerce means the bona fide use of a mark in the ordinary course of trade, where the mark serves to identify and distinguish the mark user's goods, and to indicate the source of the goods. Because the proceedings below were not in accord with this understanding of extraterritoriality, we vacate the judgment of the Court of Appeals, and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Jackson, concurring. I agree with the Court that 15 U.S.C. Section 1114(1)(a) and Section 1125(a)(1) do not apply extraterritorially. I also agree that the use in commerce of a trademark that both statutory sections describe provides the dividing line between foreign and domestic applications of these provisions. The Court has no need to elaborate today upon what it means to use a trademark in commerce, nor need it discuss how that meaning guides the permissible domestic application question in a particular case. I write separately to address those points. It is clear beyond cavil that what makes a trademark under the Lanham Act is its source identifying function. That is, under the Act, a trademark is any word, name, symbol, or device, or any combination thereof, that a person uses or intends to use to identify and distinguish his or her goods from those manufactured or sold by others and to indicate the source of the goods. Sections 1114(1)(a) and 1125(a). 1. Permit a mark owner to sue someone who is using that mark in commerce in a way likely to cause confusion, or to cause mistake, or to deceive. Critically, the Act defines use in commerce as the bona fide use of a mark in the ordinary course of trade. And, in light of the core source identifying function of marks, Congress's statutory scheme embodies a distinction between trademark uses, use of a symbol or equivalent to identify or brand a defendant's goods or services, and non-trademark uses, use of a symbol, even the same one, in a non-source identifying way. This all points to something key about what it means to use a trademark in the sense Congress prohibited, i.e., in a way likely to commit the cardinal sin of confusing consumers about source. Simply put, a use in commerce does not cease at the place the mark is first affixed, or where the item to which it is affixed is first sold. Rather, it can occur wherever the mark serves its source identifying function. So even after a trademark begins to be used in commerce, say, when goods on which it is placed are sold, that trademark is also used in commerce wherever and whenever those goods are in commerce, because as long as they are, the trademark identifies and distinguishes the source of the goods. Such a use is not free-floating. The trademark is being used by the person who put that trademark on the goods to identify and distinguish them in commerce and indicate their source. This is the use in commerce to which Section 1114(1)(a) and Section 1125(a)(1) refer. Because it is use in commerce as Congress has defined it, that provides the dividing line between foreign and domestic applications of these provisions. The permissible domestic application inquiry ought to be straightforward. If a marked good is in domestic commerce, and the mark is serving a source identifying function in the way Congress described, Section 1114(1)(a) and Section 1125(a)(1) may reach the person who is using that mark as a trademark. But if the mark is not serving that function in domestic commerce, then the conduct Congress cared about is not occurring domestically, and these provisions' purely domestic sweep cannot touch that person. Consider an example. Imagine that a German company begins making and selling handbags in Germany marked Coach, the owner's family name. Next, imagine that American students buy the bags while on spring break overseas, and upon their return home employ those bags to carry personal items. Imagine finally that a representative of Coach, the United States company, sees the students with the bags, and persuades Coach to sue the German company for Lanham Act infringement, fearing that the Coach mark will cause consumer confusion. Absent additional facts, such a claim seeks an impermissibly extraterritorial application of the Act. The mark affixed to the student's bags is not being used in commerce domestically, as the Act understands that phrase, to serve a source identifying function in the ordinary course of trade. Now, change the facts in just one respect. The American students tire of the bags 6 weeks after returning home, and resell them in this country, confusing consumers and damaging Coach's brand. Now, the marked bags are in domestic commerce. The marks that the German company affixed to them overseas continue to identify and distinguish the goods from others in the, now domestic, marketplace and to indicate the source of the goods. So the German company continues to use the mark in commerce within the meaning of the Act, thus triggering potential liability under Section 1114(1)(a) and Section 1125(a)(1). This result makes eminent sense given the source identifying function of a trademark. In brief, once the marks on its bags are serving their core source identifying function in commerce in the United States, this German company is doing, domestically, exactly what Congress sought to prescribe. Accordingly, the German company may be subject to liability for this domestic conduct, i.e., it cannot successfully obtain dismissal of the lawsuit on extraterritoriality grounds, even though it never sold the bags in or directly into the United States. Guided by this understanding of use in commerce, I join the court's opinion in full. Justice Sotomayor, with whom the Chief Justice, Justice Kagan, and Justice Barrett join, concurring in the judgment. Sections 32(1)(a) and 43(a). 1(a) of the Lanham Act prohibit trademark infringement and unfair competition activities that are likely to cause confusion, or to cause mistake, or to deceive. The issue in this case is whether, and to what extent these provisions apply to activities that occur in a foreign country. I agree with the majority's conclusion that the decision below must be vacated. I disagree, however, with the extraterritoriality framework that the court adopts today. In my view, Sections 32(1)(a) and 43(a). 1(a) of the Lanham Act extend to activities carried out abroad when there is a likelihood of consumer confusion in the United States. This court previously considered the extraterritoriality of the Lanham Act in Steele v. Bulova Watch Company. There, the court applied the Lanham Act to trademark infringement and unfair competition activities that occurred abroad but confused consumers in the United States. Because the court decided Steele 70 years ago, It had no occasion to apply the two-step framework that the court has since developed for evaluating the extraterritorial reach of a statute. A proper application of that framework, however, leads to a result consistent with Steele, although there is no clear indication that the Lanham Act provisions at issue rebut the presumption against extraterritoriality at Step 1. A domestic application of the statute can implicate foreign conduct at Step 2, so long as the plaintiff proves a likelihood of consumer confusion domestically. In Steele, the Bulova Watch Company Incorporated, a New York corporation that marketed watches under the registered U.S. mark Bulova, sued Sidney Steele, a U.S. citizen and resident of Texas with a watch business in Mexico City. Upon discovering that the mark Bulova was not registered in Mexico, Steele obtained the Mexican registration of the mark, assembled watches in Mexico using component parts he had procured from the United States and Switzerland, and stamped his watches with Bulova and sold them as such. As a result, spurious Bulovas filtered through the Mexican border into this country, causing a Bulova Watch Company's sales representative in the United States to receive numerous complaints from retail jewelers in the Mexican border area of Texas, whose customers brought in for repair defective Bulovas which upon inspection often turned out not to be products of that company. Steele committed no illegal acts within the United States. The court held that, because Steele's operations and their effects were not confined within the territorial limits of a foreign nation, the Lanham Act applied to Steele's activities. The court emphasized that Steele's conduct had the potential to reflect adversely on Bulova Watch Company's trade reputation in the United States. By contrast, the fact that Steele affixed the mark Bulova in Mexico City rather than here was not material. Following Steele, the courts of appeals developed various tests, modeled after Steele's facts, to address the Lanham Act's extraterritorial reach. This court also subsequently adopted a two-step framework for determining when a statute can apply extraterritorially to foreign conduct. That framework implements a canon of statutory construction known as the presumption against extraterritoriality. The presumption reflects the long-standing principle of American law that legislation of Congress, unless a contrary intent appears, is meant to apply only within the territorial jurisdiction of the United States. That is, courts presume that, in general, United States law governs domestically but does not rule the world. Under this framework, the court first asks whether the presumption against extraterritoriality has been rebutted by a clear, affirmative indication that the statute applies extraterritorially. If the presumption is not rebutted at that first step, the court then proceeds to determine at Step 2 whether the case involves a domestic application of the statute. To determine whether a domestic application exists, the court must ascertain the statute's focus, i.e., the object of the statute's solicitude. As I explained below, although I agree with the result the court reaches with respect to the first step, I disagree with its analysis at Step 2. Sections 32(1)(a) and 43(a), 1a of the Lanham Act impose civil liability on a defendant who uses in commerce a trademark in a manner that is likely to cause confusion, or to cause mistake, or to deceive. The Act in turn defines commerce as all commerce which may lawfully be regulated by Congress. Under this court's precedents, this language is insufficient to rebut the presumption against extraterritoriality at Step 1. The court has repeatedly held that even statutes that contain broad language in their definitions of commerce, that expressly refer to foreign commerce, do not apply abroad to all foreign conduct. The court has also explained that generic terms like any or every do not rebut the presumption. The term all is not meaningfully different. While the word conveys breadth, it does not rebut the presumption either. The court's inquiry at Step 2 centers on the focus of the statutory provisions. Like the court's analysis at Step 1, this inquiry is contextual. The court does not analyze the provision at issue in a vacuum. Rather, the court looks at the provision in concert with other relevant provisions, and considers how the statute has actually been applied. The aim of determining the statutory focus is to assess what constitutes a domestic application of the statute. An application is domestic when the object of the statute's focus is found in, or occurs in, the United States. The parties offer different interpretations of the focus of Sections 32(1)(a) and 43(a), 1a. Petitioners argue that the focus of the statute is the use of the mark in commerce. According to petitioners, the Lanham Act does not reach any infringing products sold abroad. Instead, the defendant must sell the products directly into the United States. Respondent, by contrast, argues that the Act has two distinct focuses: protecting mark owners from reputational harm, and protecting consumers from confusion. Under respondent's view, reputational harm to the mark owner is not necessarily tied to the locus of consumer confusion or the locus of the defendant's conduct. Instead, respondent asserts, harm to a mark owner's reputation is felt where the mark owner resides. The government, as amicus curiae supporting neither party, offers a middle ground. In its view, the focus of the statute is consumer confusion. Accordingly, where such effects are likely to occur in the United States, application of Sections 32(1)(a) and 43(a), 1a, is a permissible domestic application of the Act, even if the defendant's own conduct occurred elsewhere. I agree with the government's position. Sections 32(1)(a) and 43(a). 1(a) of the Act prohibits specific types of uses in commerce, uses that are likely to cause confusion, or to cause mistake, or to deceive. The statute thus makes clear that prohibiting the use in commerce is merely the means by which the statute achieves its end of protecting consumers from confusion. Stated differently, a competitor's use does not infringe a mark unless it is likely to confuse consumers. Because the statute's focus is protection against consumer confusion, the statute covers foreign infringement activities if there is a likelihood of consumer confusion in the United States and all other conditions for liability are established. Treating consumer confusion as the focus of the Act is consistent with previous case law, which focused on the domestic effects of the defendant's foreign conduct. It emphasized that, although the defendant did not affix the mark or sell the products in the United States, spurious bullavas filtered through the Mexican border into this country, causing consumer confusion here. These domestic effects could reflect adversely on Bulova Watch Company's trade reputation in the United States. In other words, consistent with the statutory text, the case focused on the impact of the defendant's foreign conduct on the consumer market in the United States, not the location of the original sale of the infringing product or the location of the trademark owner's business. The court's precedent also supports the view that an application of a statute can be considered domestic even when foreign conduct is implicated. For example, it concluded that a statute does not punish deceptive conduct, but only deceptive conduct in connection with the purchase or sale of securities in the United States. Thus, the focus of the statute is not upon the place where the deception originated, but upon purchases and sales of securities in the United States. Those purchase and sale transactions are the objects of the statute's solicitude. Under this view, a domestic application of the statute covers misrepresentations made abroad. So long as the deceptive conduct bears the requisite connection to the statute's focus, the domestic purchase or sale of a security. Similarly, under sections 32(1)(a) and 43(a), 1(a) of the Lanham Act, uses of a mark in commerce are actionable when they cause a likelihood of consumer confusion in the United States, even when the conduct originates abroad. The court agrees with petitioner's bottom line that the Lanham Act requires a domestic use in commerce. According to the majority, the use in commerce provides the dividing line between foreign and domestic applications of these Lanham Act provisions. Yet the majority does not actually take a stance on the focus of the Act or apply this court's settled law. Instead, to reach its conclusion, the majority transforms the court's extraterritoriality framework into a myopic conduct-only test. Specifically, instead of discerning the statute's focus and assessing whether that focus is found domestically, as the court's precedents command, the majority now requires a third step, an assessment of whether the conduct relevant to the focus occurred domestically, even when the focus of the statute is not conduct. Making matters even more confusing, the majority skips over the middle step of this new framework, concluding that it is unnecessary to discern the focus of the Lanham Act, because the conduct relevant to any potential focus that the parties have proffered must be use in commerce, since that is conduct mentioned in the statute. In other words, under the court's unprecedented three-step framework, no statute can reach relevant conduct abroad, no matter the true object of the statute's solicitude. The court's novel approach transforms the traditional inquiry at Step 2 into a conduct-only test, in direct conflict with this court's jurisprudence. The court has expressly recognized that a statute's focus can be conduct, parties, or interests that Congress sought to protect or regulate. After all, not every federal statute subject to an extraterritoriality analysis directly regulates conduct. Because precedent does not support the court's recitation of the extraterritoriality framework, the majority retreats to a distorted reading of the court's past decisions. The majority relies on a case that does not support the majority's course. The court in that case noted that the Racketeer Influenced and Corrupt Organizations Act's civil suit provision requires an injury to business or property. The court then concluded that there is a domestic application of that provision so long as there is a domestic injury. In other words, the court held that the focus of the statute had to occur domestically. It did not require a third step. The court also repeatedly quotes from cases where it has said that a domestic application requires that the conduct relevant to the statute's focus occurred in the United States. In those cases, however, the court first concluded, or assumed without deciding, that the focus of the provision at issue was conduct, and only then proceeded to consider whether the relevant conduct occurred domestically. In other words, the court looked to whether the focus of the statute at issue occurred domestically. In sum, none of the cases upon which the majority relies establish categorically that there must be domestic conduct in order for there to be a domestic application of a statute. Calling this requirement straightforward, established precedent does not make it so. The court's transformative approach thwarts Congress' ability to regulate important interests or parties that Congress has the power to regulate. Some statutes may have a statutory focus that is not strictly conduct, and that implicates some conduct abroad. Under the court's new categorical rule, those statutes may not cover relevant conduct occurring abroad, even if that conduct impacts domestic interests that Congress sought to protect. At bottom, by reframing the inquiry at Step 2 as a conduct-only test, the Court's new rule frustrates a key function of the presumption against extraterritoriality: to discern congressional meaning and preserve a stable background against which Congress can legislate with predictable effects to protect domestic interests, including those of U.S. trademark owners and consumers. The Court's analysis is also inconsistent with Steele. According to the Court, Steele implicated both domestic conduct and a likelihood of domestic confusion, so it offers no guidance in resolving this case. No court of appeals has read Steele that way. And for good reason. Steele clearly recognized that infringing acts consummated abroad fall under the purview of the Lanham Act when they generate consumer confusion in the United States. Finding Steele of little assistance to its blinkered approach, the majority reduces Steele to a narrow case with no application beyond its facts. Steele is no such thing. It addressed the weighty question whether the Lanham Act extends beyond the boundaries of the United States, and has guided the lower court's extraterritoriality analysis for more than 70 years. The Court should not put aside the Court's precedent merely because it is convenient to do so. Because the Court cannot ground its holding in precedent, it turns to abstract policy considerations. According to the majority, the focus of the Lanham Act cannot center on consumer confusion, despite Steele and the statute's clear textual clues, because any focus other than conduct is too uncertain and would create headaches for lower courts. The Court's conclusion, however, is based on the incorrect assumption that merely a likelihood of an effect in this country would be sufficient to hold a defendant liable under the Act. What the Lanham Act requires is a likelihood of confusion in the United States, not some abstract and undefined effect. The likelihood of confusion test comes straight from the statute's text. Assessing likelihood of confusion may require a nuanced test, but it is the test that Congress chose and that courts already apply. In addition, any plaintiff would need to do more than point to mere likelihood of confusion. As with any cause of action, the plaintiff must establish all necessary elements for recovery. For example, although use in commerce is not the statute's focus, the statute still requires that the plaintiff establish a use in commerce. As Steele shows, because commerce includes all commerce that Congress has the power to regulate, some foreign sales can fall under the statute's reach. Plaintiffs must also generally show, for example, that their injuries are proximately caused by violations of the statute. The Court is thus mistaken that abstract consumer confusion is sufficient to recover under the Lanham Act. The Court also incorrectly concludes that a test that focuses on domestic consumer confusion conflicts with the territoriality principle of trademark law. That principle recognizes that a trademark has separate legal existence in each country where the mark is registered or legally recognized. Thus, to obtain the benefits that flow from trademark rights, such as the right to a non-confused public, the plaintiff must secure those rights in the country where it wants protection. A focus on consumer confusion in the United States is consistent with that international system. The focus properly cabins the Act's reach to foreign conduct that results in infringing products causing consumer confusion domestically, while leaving to foreign jurisdictions the authority to remedy confusion within their territories. In other words, applying the Lanham Act to domestic consumer confusion promotes the benefits of U.S. trademark rights in the territory of the United States. The Court's approach, by contrast, would absolve from liability those defendants who sell infringing products abroad that reach the United States and confuse consumers here. That resulting consumer confusion in the United States, however, falls squarely within the scope of the interests that the Lanham Act seeks to protect. The Court's arguments about the impending international discord that will result from the government's approach are simply overblown. There is no evidence that Steele, which is consistent with a focus on domestic consumer confusion, has created any international tension since it was decided more than 70 years ago. Moreover, as even petitioners acknowledge, purely foreign sales with no connection to the United States are unlikely to confuse consumers domestically. Foreign companies with purely foreign operations also have at their disposal important defenses grounded in due process and international comity principles, including the ability to dismiss a case in the United States for lack of personal jurisdiction, or on the ground of forum non-convenience. Finally, the Court relies upon the amicus brief filed by the European Commission in support of its concern about the risk of international tension that the government's position supposedly creates. The European Commission filed its brief in support of neither party. However, in line with the Solicitor General's view that a focus on consumer confusion provides a more balanced approach that respects international relations while protecting against trademark infringement domestically. No sovereign nation filed its brief in support of petitioners, and the Court's restricted view of Step 2 of the extraterritoriality analysis. And there is no tension in any event. What the European Commission warns this Court against is adopting respondents' sweeping view that all foreign uses that confuse consumers abroad fall under the scope of the Act. The Lanham Act covers petitioner's activities abroad so long as respondent can show that those activities are likely to cause confusion, or to cause mistake, or to deceive in the United States, and can prove all elements necessary to establish liability under the Act. Because the courts below did not apply that test, I agree vacatur and remand is required. The court's opinion, however, instructs the court on remand to apply a test that is not supported by either the Lanham Act or this court's traditional two-step extraterritoriality framework. I therefore concur only in the judgment. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.